94th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Crystal Box. Kaylin Cheatham. Kaylin David Cheatham. It's a sanctions court. Darian Driscoll. Darian Christopher Driscoll. Rachel Haroldson. Mark Lemon. Joshua Huffman. Joshua Huffman. Guy McSpadden. Jose Molina. For the record, cause CR 24-28. Stephen Arkell Pickren is verified in Dallas County custody. We'll recall that case. I'm sorry if I mispronounced this. Lee Shinquang. Not here. Do you know he's on? He's on his way. Okay. Mr. Nicholas, do you know how you pronounce his name? Yes, sir. Thanks for the help. Trevor Blackman. Here. Joshua Chenault. Joshua Lee Chenault.
Last time I spoke to him, he was in custody, but I see that he has wanted out. I'm currently trying to reach out to his bond to see where his stuff is.
Okay. Sean Davis.
Here.
Arkia Ford. Arkia Renee Ford. Jimmy Overstreet. Jimmy Lee Overstreet. Tyler Tadlock. Christian Munes. For the record, Aaron Logan Ross, CR 24, 43, and 44. A waiver of arraignment was filed by Mr. Jeff White that was granted in pretrial that said May 28th. And Ms. Burns, for the record, on the waiver of arraignments, if you're not aware, there's order language at the bottom for them to check in within 10 days of signing the waiver being signed, check in with pretrial release. So if he doesn't check in within 10 days, you can let me know. Larry Wayne Marshall. Here. And Mr. Castro Goa is at 10 a.m. Mr. Perez is home.
It's after.
Oh, Lenol Perez. Yeah, Lenol Perez at 10 a.m. Okay. But you said he's here. Okay. All right. Are there any attorneys that are ready? Sure. Mr. Schmidt, you ready? Yes, Your Honor. Mr. Munes, if you'll come forward, please, sir. This is cause number CR 23-224, State versus Christian Saul Munes for docket call. Go ahead, Mr. Schmidt.
Your Honor, there's a couple items the state is looking into. We don't know if it's outstanding discovery or not. Ms. Curry is looking into that with the hospital. In addition, we are working on some information for her. And so I think both sides are requesting that we pass this docket call if possible.
Any objections from the state?
No, Your Honor, that's correct.
Do we believe 30 days to be sufficient for all to wrap up the information you need or more?
What do you think? Judge, I'll be back May 16th. I think that would give us time.
Okay. All right. Court says Mr. Munes for docket call on May 16th. at 9 a.m. Once he signs and gets his notice, he's free to go.
Thank you, Your Honor. We'll step back and I'll have him sign that.
All right, and approach before you leave.
Yes, sir. I'm going to be around.
Okay. Wyatt, are you ready on Larry Wayne Marshall? Yes, sir, I am. Mr. Marshall, you'll go ahead and start making your way forward. All right, this is cause number CR 23-222, State versus Larry Wayne Marshall, docket call. Go ahead,
Your
Mr.
Honor.
Wyatt.
I spoke with Mr. Hartwell last week on this case. We're still trying to work through it. He addressed another case with me at the first part of this week, but we didn't address this one. I'm afraid it may have just been an oversight. And since he's not here today, I'd asked for a short reset so we can maybe avoid a trial if possible.
Any objection from the state?
No, Your Honor, thank you.
You know the next time you're coming back, Mr. White.
No, sir, I don't, but whenever you tell me to be here, I will.
Okay. Let's do final docket call May 16th.
Yes, sir.
Free to go.
That's all I have.
Thank you, Mr. White. Who are you ready on?
Judge, if we can actually start with Mr. Chenault. After you called the case, I learned that Mr. Chenault is being represented by, or is, as a bondsman other than the one that was listed on the notice of setting. So the notice of setting that was sent on April 9th of 2024 was sent to myself and A. Springer. However, I learned that Mr. Nicholas is his bondsman on this charge currently. So I believe they're trying to figure that out. It looks like notice wasn't properly sent.
We're set for a plea today, aren't we?
Yes, Judge.
So wasn't there a notice of setting in open court?
No, Judge. He was actually in jail. He was on the trial docket. And we,
Saying how do we set it for plea? Did you just call the coordinator and set it?
I requested it be set. Yes, Judge. And then I later learned that he was no longer in jail.
Okay. Do you want to wait and see if the bondsman can get a hold of him and get him up here?
If that's all right,
Okay,
Judge.
we'll just recall the case.
Thank you. Ready on Miss Rachel Haroldson.
Ms. Haroldson? No, just don't do that. Just go on around. It's there for a reason.
Judge, we're here for arraignment on Miss Haroldson. I just got appointed. I've had an opportunity to go over the
Hang on,
indictment.
Let me get this on the record.
Yes,
first, okay? This is cause number CR 22-377, State versus Rachel Danielle Haroldson for arraignment. Go ahead, Mr. Manning.
Judge, I have recently been appointed on Ms. Harrelson's case, received a copy of the indictment, went over that with my client. She understands, sorry, her name is spelled correctly. She understands the charges against her, and this time she pleads not guilty. We had additionally request a setting for pretrial and discovery in this case.
All right, court finds that Ms. Haroldson has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record. We'll set this matter for pretrial hearing. Mr. Manning, the next Thursday setting that I have, that's a regular docket, 30 days out or so is May 16th. If that's not enough time, then we'd be looking at June 13th.
Let me just speak to my, if I just speak to my client. Judge, if we can take the June date, that way I can get all the discovery and have an opportunity to go over that with my client, prepare a defense.
All right, court sets Ms. Haroldson for pretrial hearing on June 13th at 9 a.m. Once she signs and gets her notice, she's free to go.
Thank you, Judge. Judge, next ready on Mr. Trevor Blackman.
Mr. Blackman, you come forward. This is cause number CR 23-200, State versus Trevor Troyce Blackman for pretrial. Go ahead, Mr. Green.
Thank you, Judge. Mr. Blackman is set for, I believe, our first pretrial. We have had an opportunity to go over the discovery in his case. However, there is a question regarding restitution. I made a request for restitution and clarification back at our last court setting. I have not heard back as to what that number is going to be. I do believe we have a resolution in this case. We're just waiting on that number to determine the length of the probation as well as how much money will be owed for that restitution.
Anything from the state?
No, Your Honor. No.
Is Mr. Hartwell working on this case?
Yes, Judge. This is Mr. Hartwell's case.
All right, we'll set Mr. Blackman then for. Yeah, so you're not worried about any pretrial issues, just time.
Not at this time, but if the number that they have is incorrect, we'd like to have a hearing on restitution.
All right, we'll set this matter for docket call May 16th. 9 a.m.
Thank you, Judge. Ready on Mr. Sean Davis.
Mr. Davis, this is cause numbers CR 2395, 207, 208, 209. Neighbor Ron Ray Davis. Go ahead.
Yes, Judge. Since our last court setting, my schedule has not permitted me to go to the DA's office to review the evidence on the newly indicted cases in 207, 208, and 209. I request additional pretrial to go over to the DA's office and see what we got.
Any objections from the state?
No, Your Honor. Thank you.
All right, then we'll set Mr. Davis. You want to do that June 13th date?
Yes, please, Judge.
All right, court sets Mr. Davis for pretrial in each case June 13th, 9 a.m. Who's next?
Judge, next ready on Mr. Overstreet.
Jimmy Lee Overstreet. CR 23239 for pretrial. Go ahead, Mr. Ray.
Judge, at this time, we have no contested pretrial issues. Request to be set on the docket call.
All right, court will set Mr. Overstreet for docket call on May 16th. 9 a.m. Once he gets his notice, he's free to go.
Judge, also, I would note that we've requested at this point, multiple times requested an offer on Mr. Overstreet's case. And we're still waiting on that as well.
Does the state intend on making an offer? on-
I've made a note of that, Your Honor, and we'll follow up with Mr. Manning. Thank you.
Who's next, Mr. Man?
Judge, I believe that's all that I have that are currently here. Mr. Tadlock is going to be a plea, and I'm waiting to, I don't know if we have the paperwork ready on Mr. Tadlock.
Tadlock. Stephanie just texted me.
All right, this is cause number CR 24-41, State versus Crystal Lynn Box for arraignment.
Judge, if I may just have one moment.
Go ahead.
Judge, Ms. Box's name is spelled correctly. She understands the charge against her. At this time, she's pleading not guilty. Request to be set on pretrial docket.
All right, court finds that Ms. Box has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record. Court sets this matter for pretrial hearing on June 13th at 9 a.m. Judge. Ms. Box, have you met with the pretrial release officer yet?
I have.
Okay, so you've posted bail in this case.
Yes, sir.
Okay, so the court is going to place you on conditions of pretrial release, which are also known as conditions of bond or bail.
Okay.
Means that you're gonna have to report to a pretrial release officer. You're gonna be drug tested.
Yes.
If you violate any of these conditions, the court could revoke your bail and put you back in jail. So once you sign the notice, then go over here and have a seat, and then the pretrial release officer would be with you in just a moment. They'll go through all that paperwork with you.
Okay.
All right. All right, Mr. Manning, ready on anyone else?
Yes, Judge. Also have an appointment for Jose Molina.
Mr. Molina? All right, this is cause number CR 24-27, State versus Jose Angel Molina for arraignment.
Yes, Judge. If I may just have a moment to go over the indictment by plan.
Yes, sir.
Yes.
Go ahead, Mr. Manning.
Judge, Mr. Molina's name is spelled correctly. He understands the charge against him and pleads not guilty at this time. The request to be set on the pretrial docket in order to get discovery.
All right, court finds that Jose Molina has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record. We'll set this matter for pretrial hearing on June 13th at 9 a.m. Once Mr. Molina signs his notice, Mr. Manning, he needs to meet with a pretrial release officer to sign his conditions of pretrial release.
Yes, Judge. Yes, right there. And then once you get done with your, on the bench, I'll discuss your case with the company. It's a good block this way.
Anyone else, Mr. Manning?
Judge, I believe that is all I have ready right now. The state's informed me that they should have his plea paperwork done shortly.
Mr. Tadlock?
Yes, Judge.
Okay. Is Kayla Cheatham here? Darian Driscoll? Go call that name just a Mr. Lincoln's. Mr. Mpad, come up here and meet with Mr. West so you give a UA before I call your case.
It's not a revocation motion. Misdemeanor.
Mr. Lemon, come on up. This is sanctions. This is sanctions court hearing and cause number CR 15463, Say versus Mark Lemon. Mr. Lemon, this is your first time in sanctions court, correct?
Yeah.
You know what sanctions court is about?
No.
Sanctions court is an intervention program created by this court to try to get the attention of people who are on probation to prevent them from going to prison. People like you.
Yeah, don't want to.
People like you who walk into my courtroom positive for methamphetamine. So the probation office is well within their rights to go and ask these prosecutors to file a motion to revoke, ask me to sign that, issue a warrant for you, put you in custody today, take you over to jail, give you an opportunity to have an attorney, come back, have a hearing, and determine whether or not you're on deferred for a first degree felony, manufacture, delivery, minimum 5, maximum 99 or life. And they could argue that you violated. They can argue that your probation should be revoked. You should be sentenced to prison. They're all within their rights under the law to do that. But the sanctions program is an attempt by this court to get the attention of people like you to determine whether or not we really need to take you out of society and put you in a cage. That's what we're trying to decide. Okay. So when I get a note that says you're being supervised in Travis County and you're not submitting to UAs, hang on, that you left the lab, you're not working your community service, things of that nature, that tells me that you're not, hang on. See, here's a problem. Here's a problem. You're not listening to what I'm saying. You're still not listening. You're shaking your head, you're looking off, and all you're thinking about is the first thing you're going to say when I quit talking. And that's a problem. That's a problem. Because I hold the keys as to whether you do 9 days in jail as a sanction for your methamphetamine, or I say, you know what, this guy is not ready for community supervision. Go file a motion to revoke, or you to sit there. I'll sign the warrant. I'll have these officers take you into custody. That's where you're at right now. So before you say another word, before you think about another word, I want you to really think about, is it worth it? Okay. I'm just telling you what, I'm going to give you a chance to be heard. Okay. I'm going to give you a chance to be heard, but I need you to listen to me first, because the things that I'm telling you are important for you to know. We understand each other now?
Yes.
Okay. That's what's being reported to me. And then when you show up here and I'm getting ready to have a hearing and I UA you and you're doing methamphetamine while you're on probation, that's already not starting on the right foot. So you need to know what your future holds. You understand?
Yes.
What is it that you want to say that's so compelling?
I don't have anything to say.
Well, no, you wanted to say something. Now is your opportunity. Say it.
Mm,
Don't tell me, oh, I am working probation. I
no,
am doing my
I went
community
to take
service.
the UA in Travis County, and what happened was I couldn't pee at the time, and he said he was gonna mark it down as a fail. So I said, okay, I guess that's what you're gonna do, and that's what he did. They didn't ask me to stay there or anything, so
Would you have been hot? Honestly, would you have been hot?
I
Probably, yeah.
I probably would have been.
So you're arguing a point that
Oh,
makes
but,
no sense. I mean, you're
I'm
probably hot. I mean, you're hot now, so it's kind of moot, but I understand what you're saying. I understand what you're saying. But if they tell you, hey, you got to give a drug test, and they give you opportunity, they give you time. If you don't do it, they're not going to wait on you forever. They're going to deem it as a positive and move on, because that's what they have to do. But it doesn't change the fact that you're hot today.
Yeah, it doesn't.
Yeah. So you got a drug problem.
Try and take care of them.
So we need to figure out, A, are you going to get help while you're free? Or B, are you going to get help while you're in custody? That's what we need to figure out.
A sounds better.
Yeah, B sounds better, but I don't know that you can handle B. Well, B is custody.
No, A's, yeah, you said, yeah, A's.
A while you're free,
and
B is while you're in custody. So I don't know if you can handle A. We're going to find out. Can you handle A?
you can, yes,
So what's your plan?
to get help, more help than I already have.
Right. I mean, saying it is one thing, but I'm saying,
Doing it is another.
what's your plan? How are you going to get help?
Jeez,
If you don't know, the first place you need to start is your probation officer.
Okay.
It's the first place you need to start. People oftentimes view their probation officers as their enemy, when in fact, it's quite the opposite. Probation officers are there to help you comply, give you access to resources, tell you what you can do, whether it's Narcotics Anonymous, whether it's counseling, inpatient, outpatient, things like that. You got to talk to them and you got to let them know you're struggling. The worst thing you can do is try to hide your drug problem and try to hide your positive test and drug usage and hope not to get caught. That's the worst thing you can do, because that's not addressing the problem.
Right.
Understand? Yes. All right, so this is what we're going to do, Mark. I'm going to reset you for another sanctions court hearing. Where do you live?
Austin.
You live in Austin, so you have to come up here.
Yes.
You know, Mark, I just remembered who you are. I just remembered who you are. It's taken me a minute.
It's been 5 years.
Yeah, it's been a long time. And let me tell you the reason that I now know who you are. You were the first defendant that came in here while I became a judge on January 1st of 2019. And when I sat down there at that table, I had a policy that said no probation for drug dealers. And you were arrested, I think, over in Grand Saline.
Yeah.
And you had a large amount of methamphetamine.
Yes.
Just listen, yeah, large amount of methamphetamine. And you were charged with manufactured delivery based on the quantity. We had a hearing. And the prosecutor stood up and they argued that they have a policy that they don't give probation to drug dealers, knowing that that was the policy that I'd instituted in that office and that they were following the same policy, expecting me to follow suit. But your attorney stood up and argued, heard about your daughter, I believe. You were working in HVAC, installer down in
Awesome.
character,
Company.
it was 5 years ago, character references for you. And I said, the first time as a judge, I realized that I wore a different hat than when I sat over there. And that policies are not, always one fits all. And I looked at you as an individual and I decided, you know what, I'm not going to follow that same policy. And I went against conventional policy and wisdom. And I said, no, I'm going to give him a chance. And I'll tell you, Mark, I've been bragging on you prior to this day. I've been bragging on you because I said it taught me a lesson that there's individuals that can defy the norm and they can change. And I bragged about you. Here we are. Now, I'm not saying that I made the wrong decision. And I'm not saying that you screwed everything up and that you take that story away. I'm not saying that at all. I'm just saying I'm disappointed. Because I did remember you. So what we're going to do to get you back to where you were, that's the question that I'm posing, and that's what I've got to figure out. And let me tell you what I'm going to do. I'm going to do the only thing I know to do, and that's to give you time to show me that you can remain on probation, that you can do what you say that you're going to do. I ordered you to do 500 hours of community service back on April 15th of 2019, and you've done 10 in 5 years. So just listen, you've done 10 in 5 years. It's a problem. You're supposed to expire in April of 2029. So you still got 5 years to go, so that you have plenty of time to right the ship before it sinks. And when the ship sinks, you go down with it. Anybody else you got on your ship, significant other, you have a daughter, right? How many?
Oh, I have 5 total.
Five
But,
total.
I two live in Houston, two I've never seen, and I got an 18-month-old.
So there's people that are on your ship.
Yeah, and then I got married, 123, 123.
So there's a lot of people on your ship. So if your ship goes down, they're either gonna drown with you or they're gonna have to abandon ship and go to someone else's ship, correct?
Correct.
You're the captain of your ship. It's not me. It's not me. I really don't decide where your ship goes. You do. Your actions, right? I'm gonna bring you back. I'm gonna reset you for Tuesday, May 28th. I'm gonna tell you that these are things that you have to accomplish before May 28th so that I can try to right your ship. Okay? These are things that have to be done. If you don't do them, then it's just gonna create more consequences for you. Okay? You're gonna have to pay $100 to the probation office for your fees. You're gonna have to pay $150. We're writing this down for you. $150 towards your court costs. You're gonna have to work 10 hours community service. That's the same amount that you've already worked in 5 years. You're gonna have to find a weekend. You're gonna have to get that done. If you don't work on the weekend, if you work on the weekends and not during the week, or you're in Travis County in Austin, I'm sure there's things that you can do at night. You just got to find out where you can go to your probation officer, find out which areas are approved for that. Don't go out and volunteer somewhere and expect it to be approved. Doesn't work like that.
Yeah.
Go to the approved list. I need you to attend your, you know what your IOP?
Yeah,
What's that?
that's intensive outpatient.
Okay, I need you to attend that. I was set on giving you 9 days in jail as a condition, as a sanction for being hot for methamphetamine today. But I tell you what, I'm not gonna do that. I'm not gonna do that. Rather, the probation office is gonna save that as a violation. And if down the road, you don't do what you're supposed to, then they're gonna give that information to the state of Texas and they're gonna use that against you in court. So that you know, it doesn't mean that you've done methamphetamine, you've been caught, and it doesn't matter. It means that it's deferred right now. We're gonna put that out in the future. If you do what you're supposed to, that's not gonna come back to hurt you. If you don't do what you're supposed to, it's gonna be something that your defense attorney is gonna have to defend against. Does that make sense?
Yes.
All of these things have to be done, completed, and reported to the probation office before noon on Friday, before you come back to court. The Friday of the week before you come to court. All right, Mark, go ahead and sign that notice form, and we're gonna see you back on May 28th.
I remember you had me sign one of these and you said typically there are no bonds. I don't remember what kind that was. Okay, so I need to fill in that last page and put in bond. Do that, and then I've already signed those for you. I just crossed out the S because there's no S in methamphetamine. Sure.
Good morning.
Holly, how are you?
Good. How are you, Judge?
Excellent. All right, you just set up here.
She just stepped down. She's not with the family. Okay.
You'll have to unmute them and make sure that it's selecting. It's because I've got to learn to unmute myself. Hey, can I get you to go ahead and state your name and your license number for the record? Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. All right, for the record, this is cause number CR 21389 State versus Lenol Perez. We are set for a docket call today. Mr. Dooley, any announcements?
Judge, defense is ready for trial. We would request a special set, Judge, if we could get one, due to the fact that I do believe I'll have a minimum of one out-of-state witness.
All right, and can, Mr. Dooley, can you tell me, has an offer been made by the state that your client's rejecting today?
The offer has been made by the state, Judge. The offer was 5 years deferred adjudication. That offer was declined.
And it's important for your client to understand that the court's policy is that after docket call and the rejection of any offer or counter offers, that the court does not allow the parties to continue engaging in plea negotiations. That once a jury trial is requested, then a jury trial would be given. That means that if Mr. Perez changes his mind on the Friday before or the Monday morning of trial, the court's not going to be inclined to allow Mr. Perez to enter any type of plea agreement. Does your client understand that?
I understand, Judge, and I think we've actually had this conversation before. I thank you for clarifying that for him. I've explained that to him, as you have, I think, twice now. And I believe that all indications are that we're going to have trial, Judge.
Okay. And Ms. Bill, can you ask Mr. Perez if he has any questions about what the court has stated thus far?
No, está bien.
All right, so Mr. Dooley, I'll take your request for a special setting on this case. However, I'll tell you that this type of case does not receive priority settings for special set cases because it's not a crime against a child or a crime of violence or a crime involving a death. However, I will tell you that Mr. Perez will be placed on the court's rolling trial dockets, which will be they will back up the special set cases. So if a special set case goes away, then those are the cases that will be liable for trial. You'll know when your case is within the top 10. And I'm sure that the state will cooperate with you in determining really the realistic possibility of going to trial so that you can line up your out-of-state witness. Right? So Mr. Perez, beginning on Monday, May 6th, you're required to appear at the courthouse for your jury selection setting. You will not go to trial on that date. However, you will meet with court staff and you will receive a reset notice for your next jury selection date. And you'll continue to do that until your case is reached for trial. Mr. Dooley is not going to be required to be here on that date. He will only be required to be here once your case reaches the top 10 cases for trial. And Mr. Dooley, you will be notified of that when that happens. Ms. Taberhand will send out the notice of the top 10 to all attorneys on that list to let you know that you need to be here in case your case goes to trial.
Yes, sir.
And once you receive that, my recommendation is to reach out to the state, talk with them and find out who they're really looking at trying or not trying, because as you know and are aware, cases plea, some things happen, cases get dismissed, things of that nature. So stay in contact with the state.
Yes, sir.
All right, so Mr. Perez, we'll see you back on Monday, May 6th. You'll meet, you'll come in, you won't come into the courtroom because we'll be picking a trial on another case that day. However, you will meet with Ms. Taberham and the pretrial release officer will be downstairs to talk to you about any issues that they have, and they'll give you a new date and a reset notice you'll sign, and you'll be able to leave. Make sure that you stay in contact with your bondsman as well.
Okay.
All right. If there's no questions from Mr. Perez, we'll go ahead and set his notice of setting. Do you have a notice of setting, Mr. Dooley?
I haven't done one yet, Judge.
All right, let's get one filled out. Once he signs, and he is free to go.
Thank you, Judge.
You're welcome.
How are you?
See you.
Okay. Holly, it'll be just one moment, and then we will have Mr. Castro Goa. I'll let you know his attorney is not present. But we're still going to conduct the hearing. Thank you. Be just. All right, Holly, we're gonna go ahead and get Mr. Gouveia set up, see if you can establish communication.
Sí. Sí.
All right. Thank you, Ms. Bill. All right, this is cause number CR 23-166, State of Texas versus Miguel Angel Castro Goa. We're set for docket call today. The record will reflect that Mr. Balderrama, Mr. Alban, attorneys for Mr. Castro are not present today. They've indicated to the court that they are in trial in Tarrant County. And so the court has inquired with the state as to the nature of the setting. And Ms. Curry, at this time, do you have any announcements regarding any communication with counsel for the defense and any announcements on docket call?
Your Honor, I have been communicating steadily with counsel for the defendant. We have no announcement regarding a resolution at this time. We are working towards one. We just asked for another docket call where counsel can be present.
Mr. Curry, Ms. Curry, do you believe that there's any reason we should set this for a final docket call within 30 days so we get a final decision? Is there anything that the state or the defense is working on that needs more time than that?
Your Honor, I know that the defense was having some independent testing done. However, that has been about 60 days ago. Of course, they do not have to tell me the results of that testing. So I have no reason to believe that it's not completed. So I think that 30 days would be sufficient for a final docket call.
All right, court's going to set Mr. Castro Goa for a final docket call on Thursday, May 16th. It's a little less than 30 days, but pretty close. And so I will expect an announcement from the state and the defense as to whether this case is going to be set for trial or whether it's going to be resolved by a plea agreement or some other resolution. Mr. Goa, have you given your drug urinalysis test yet? Have you submitted a urine sample?
Sí, ya.
Okay, so I want you to remain in the courtroom until I get the results of that, okay?
Okay.
All right, so Mr. West said that he has conducted the urinalysis test and you're negative, so you're free to go. Once you get your notice, you're free to go.
Ok, gracias.
Do you have any questions, Mr. Goa?
Nada. No, no tengo ninguna.
All right, make sure you stay in contact with your attorneys.
Lo haré.
Ms. Abraham, are we finished with Ms. Beal?
Yes, Your Honor.
Holly, thank you again so much for being here. We appreciate you being here, and if there's anything we can do to make your job easier, you let us know. Great. Have a good weekend. All right, court's going to stand in recess for 20 minutes, allow Mr. Manning time to work on his paperwork. We'll be back. It's about 10:30, so I'll be back about 10 till. All right, Mr. McSpadden, come on up. This is the sanctions court hearing. This is Guy Ezekiel Mpad, CR 2236 for sanctions court. Let's see, Mr. McSpadden, this is your first time in sanctions court today, correct?
Yes, sir.
I notes say that there's never been a payment to probation. You've only made one payment to your court fees. You haven't worked your community service. See here that you've had some medical issues. You haven't worked in your community service and you've not provided any kind of medical documentation from a doctor indicating your inability to do that. Tell me what's going on.
Judge, I submitted paperwork, shortly after I was put on probation through you guys. I had, a hernia surgery, two of them actually, and I submitted it to the probation people. I do my probation out of Wood County, and in fact, last month I had a third surgery and submitted it through Wood County again. Also with, I haven't been working on that. I'm a disabled vet. I do work on the side like construction and stuff like that. Disabled vet, I get $173, and I just, hopefully this week or next week, I get cleared from this last hernia surgery, and I already got a spot picked up for community service, all that stuff. And it's just been medical pretty much.
Are you able to comply with your financial obligations?
I have help from the state for food stamps assistance and stuff like that.
How much money do you make a month?
$173 plus $290 for food stamps.
That's total.
Yes, sir, because I own property and everything, so
You said you what?
we own the property, so it ain't like I have to pay rent or anything like that.
You do, or your family, or who?
Family.
And do you live with your family?
Yes, sir. It's me and my mom. We live on the property. I take care of her. She has just diagnosed with cancer.
All right, so because I want to be very transparent with you. Your UA says that you were positive for THC and methamphetamine.
Yeah, I'm never in the last 2 years, even with CPS and hair follicle, I've never failed a test, so I don't know.
I'm gonna send that off to the lab for confirmation. If it comes back and says you're positive for methamphetamine, our next hearing is gonna have a different tone to it.
Yes, sir.
So that you're aware. So I'm gonna bring you back on Thursday, May 16th.
Yes, sir.
Once you get cleared from your surgery, are you gonna be able to work?
I plan on jumping on my community service and trying to do a part-time job.
How much money do you usually make when you're not dealing with your medical issues, when you're working part-time?
Depends on what job. I do pretty good, pretty much.
All right, I'll tell you what I'm gonna do. I'm gonna order you to pay $60 to probation, $40 to court collections. That's a total $100. And I'm not gonna order any CSR at this time. I'm gonna wait, and I want you to bring all your medical documentation to the probation office here in Canton, so that we'll know what you can and can't do on your community service.
Yes, sir. I'm scheduled to go to Wood County on the 22nd. I'll make sure to get everything that I gave her and bring to you guys.
Yeah, do that. And we'll request it from them also, but just in case they don't do it. So when you come back, I expect a $60 payment to probation,
Yes, sir.
$40 payment to court collections.
Yes, sir.
And then we'll talk about your drug lab results.
Yes, sir.
We'll talk about community service and other things. All right, so
Yes, sir.
May 16th, I need those both payments made before on or before the Friday before that court date. So if you're coming back on Thursday the 16th, that stuff needs to be paid by Friday the 10th by noon.
Friday the 10th by noon.
Friday the 10th by noon, so that we can get that paperwork in, get it processed, so we know it's done.
Yes, sir.
Okay,
Yes,
you're
Judge.
gonna bring you something to sign.
Thank you, Judge. Thank you, Judge.
Welcome. Yes, please.
So we've got
Court calls cause numbers CR 2376, CR 23190, CR 23191, CR 23192, CR 23193. State of Texas versus Tyler Jason Tadlock. Mr. Tadlock, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Mr. Tadlock, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
ADHD. I don't know if that's.
Yeah, yes, that qualifies. Are you currently on medication or undergoing treatment for that? Do you feel like that ADHD is any way prohibiting you from understanding what's going on in these cases here today?
No, sir.
Okay, and in all of these cases, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes, sir.
You feel like you've had enough time to talk with him about all of these cases to the point that you understand all of your legal rights and that you don't have any questions?
Yes, sir.
Mr. Manning, do you believe that Mr. Tadlock is competent to enter into a plea agreement today?
I do, Judge.
And you've explained to him his rights as they pertain to all of these cases, including the advantages and disadvantages of a deferred adjudication plea?
I have explained those, Judge, and he is grateful for the opportunity to have this chance deferred. I've explained to him there's pros and cons, and I've explained to him how he avoids violation in detail throughout our conversation this morning.
And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Tadlock, I need to discuss the law with you regarding these charges just briefly. In cause number CR 2376, you are charged by indictment with aggravated assault with a deadly weapon. In fact, that's the same charge in all three of your cases, part of your plea agreement today. All three of those cases are a second-degree felony offense that do carry ranges of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, should you be convicted and confined. In addition, a fine may be imposed not to exceed $10,000. I see that the plea agreement in these cases is that the state, upon your plea of guilt, is recommending to the court that the court defer a finding of guilt and place you on community supervision for a period of 8 years. What that means, Mr. Tadlock, is that the court's going to consider the evidence, and if I find there's enough evidence to convict you of these offenses, and if I follow the plea agreement, that means the court's not going to convict you of these offenses. Rather, the court's going to place you on community supervision for a period of 8 years. If you successfully complete all 8 years, then the cases will be dismissed and you will not be a convicted felon. You understand that?
Yes, sir.
There's also a possibility that if you violate any of the terms and conditions of your community supervision during that 8 years, the state could file a motion to adjudicate your guilt. That means to have the court find you guilty of these offenses, make you a convicted felon. And then the state could also ask the court to do a number of things, including revoking your community supervision, placing you in prison anywhere from the minimum 2 years all the way up to the maximum 20 years. You understand that as well?
Yes, sir.
See that part of your plea agreement, you're agreeing to fines of a fine of $2,000 in one case, no fines in the other cases. However, you're going to be required to pay court costs of $290 in each one of your cases. And it looks like the DA's office is going to wrap up some other cases that you have pending, a violation of a bond or protective order, an assault causes bodily injury to a family member, a tampering, fabricating with physical evidence, a theft of a firearm. And in addition, you'll have a weapon forfeiture. Is that your understanding of the plea agreement in these cases, Mr. Tadlock?
Yes, sir.
All right, understanding the plea agreements, understanding the range of punishment for these offenses, Mr. Tadlock, how do you plead to aggravated assault with a deadly weapon in each one of these cases?
Guilty.
Are you pleading guilty to each one of these crimes because you are in fact guilty of committing each one of these crimes?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection. I would note on CR 23-192 and 193, the name of the complaining witness was misspelled, and we corrected that by interlineation. But other than that, we have no objections to the stipulations of evidence in all three cases.
All right, then stipulation is admitted. Court takes judicial notice of Mr. Tadlock's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Judge, I just would note that Mr. Tadlock, in my time of representing him, has come quite a long way, both in his acceptance of his actions in this case, but as well as building his support system around him. At our last hearing, he had not only his father and other family members who were all there helping, making sure that he had everything he needed and asking questions on his behalf. And so I think my hope is that Mr. Tadlock takes these conditions seriously. I think he has a system in place to be able to do so. In my conversation with him today, I think he's ready to show the court what he can do on his behalf.
Thank you, Mr. Manning. And Mr. Hernandez, do we have victim notification compliance? Are the victims supportive of these recommendations by the state?
Yeah, Your Honor, my understanding is there was notification. I don't know exactly if they were in agreement.
And Judge, I would note these were Mr. Hartwell's cases.
Do you have any information for the court as to whether or not the victims are supportive or not supportive?
I do not have any, Judge. This is our third itineration of a plea agreement, so I'm not sure if they were specifically consulted on this one.
If I may have 30 seconds, I can probably reach out to our victim coordinator and get that.
Yes, please.
If I may. Your Honor, we are in compliance. The victim impact statements were sent out, but they were never returned. So that's all the information I have for the court.
Thank you, Mr. Hernandez. All right, the court's going to review the evidence. All right, court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of these offenses. The court is going to follow the recommendation of the state of Texas, plea agreement with the defendant. The court in cause number CR 2376 defers a finding of guilt on the second-degree felony offensive aggravated assault with a deadly weapon. Places Mr. Tadlock on 8 years community supervision. Orders him to pay a $2,000 fine, $555 reimbursement fees, $290 in court cost. As part of this plea agreement, the court does dismiss pursuant to section 1245, a unfiled DA cases on violation of a bond protective order, assault causes bodily injury of a family member, tampering or fabricating with physical evidence, and theft of a firearm. In addition, the court finds that a weapon was used and shall be forfeited to the Van Zandt County Sheriff's Office as ordered in the judgment. In cause number CR 23-192, the court follows the same recommendation and plea agreement, defers the finding of guilt on aggravated assault with a deadly weapon, places Mr. Tadlock on 8 years community supervision, orders that his community supervision run concurrent with cause number CR 2376 and CR 23-191. Court also imposes court costs of $290, reimbursement fees of $35. In cause number CR 23-193, court defers a finding of guilt on aggravated assault with a deadly weapon, places Mr. Tadlock on 8 years community supervision, orders that his community supervision run concurrent with the other two causes, and the court dismisses under section 1245 DA case unfiled unlawful carrying of a weapon, imposes court costs of $290, reimbursement fees of $35. Mr. Tadlock, how old are you?
22.
22. That's quite a young age to be facing potentially 20 years in prison. Wouldn't you agree?
Yes, sir.
I want you to know that when you walk out of this courtroom and you're on probation, that if you do not comply with your probation conditions, if you don't do what Mr. Manning said and take it seriously, I want you to know that you will most assuredly end up in prison for a very long time.
Yes, sir.
If you violate your conditions of probation, that could be the reason that your probation gets revoked. And if you get revoked and you get sentenced, you won't be sentenced because you smoke weed or because you don't do your probation. You're going to get sentenced because of what you did in these cases. These are serious cases. That's why I asked the state if they complied with the victims. Pointing guns at people, hitting people with guns, shooting guns towards people in their vicinity. Those are all very serious. If you violate your conditions of community supervision, you're going to be looking at upwards of 20 years, and that's a long time. You could go into prison a very young man and come out a middle-aged man. So I want you to understand how serious this is. As a 22-year-old man, and I'm using that word man because legally that's what you are. You're an adult. I don't know if mentally you're an adult yet. I don't know if you're mature enough as an adult yet. I don't know if your mother or anybody still having to take care of you. I don't know if anybody's having to support you. I don't know if you have a job. I don't know all those things. But I hope that you take it serious and you mature pretty quick because there's a lot of conditions in here you're going to have to comply with.
Yes, sir.
People think that probation, people who've never been on probation think it's a slap on the wrist. They don't understand how onerous it is to comply to stay out of prison. So this has to be the most important thing in your life right now. Not your friends, not your family. Other than your relationship with God, this has got to be the most important thing that you do because these, it might not look like it, but these are the keys to your jail cell right here.
Yes, sir.
Right now, your jail cell door is open. You can go and you're going to be in custody in the community. You're still in my custody in the community. But if you screw that up, then I'm going to take these keys away from you. And that door's going to close.
Yes, sir. I understand.
You're going to be locked up. I can't stress that enough to you. I don't want to sit here and have this conversation at a revocation hearing. I don't want to have to explain to you why I'm giving you 20 years in prison. I want you to already know that. And when you wake up in the morning, I want you to think about it. When you go to bed at night, I want you to think about it. 8 years is a long time.
Yes, sir.
Very important. You understand?
Yes, sir.
All right, Mr. Tadlock, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come up here to be fingerprinted with Deputy Martinez, and then you can meet with the probation officers and they'll tell you about what's next.
Yes, sir.
Mr. Tadlock's gonna go back here in the room and fill out his paperwork, and he's gonna come out another way. So if you just want to wait for him in the hallway.
And Judge, on Miss Ford's case, I will do my best to reach out and contact her. I don't believe I have a contact information due to the fact that she was incarcerated at my time of appointment. but I'll reach out and see if I can track her down. If so, would the court consider holding off the NISI or the bond revocation until tomorrow at noon?
Court will take a judgment nisi under advisement until tomorrow at noon. If you reach Miss Ford, then she needs to appear to Miss Taberham before 5 p.m. tomorrow in order to discuss a reset. And what I would like to do is if you do get a hold of her, that she come meet with you, that you file a waiver of arraignment, and that she come over here and get a setting.
Yes, Judge. Has she already signed conditions of pretrial release?
Yes, I believe she has.
Okay.
Show that she's delinquent $660, and her last report was in August of 23.
Yes, Judge. I believe that concludes my business. May I be excused?
Yes, sir. Conditions of pretrial release. Yeah, I need Darian Driscoll's name called. I want you to call Joshua Huffman. That's a pretrial release, not.
You
Go ahead and call
get all
his
the
name.
intake done.
We also need to reset Stephen Pickren. For the record, Mr. Hernandez.
Yes.
Stephen Pickron, CR 2428, no attorney, set for arraignment today. We have verified him in Dallas County custody. So we're just gonna reset that for. Not sure what his holds are. Let's reset that to. No, we'll reset that to Tuesday, May 28th for arraignment. We'll check the custody again. All right, let's see. We also need to call Lee King. No, Shin King, like I said it. Shane King, like I said it. No, Shin King, like I said it. That's it. Shane King. No, no. Shane King. Shan King. It's very important that you get it right. All right, so I want you to call Driscoll, Huffman, Shan King, and Ford. No, Shan King. I feel like this is a broken record. All right, the court has called the following names who were not present in court. Their names have all been called loudly distinctly 3 times in the courthouse with no response. The court is hereby issuing judgment nisi and habeas corpus on Darian Driscoll, Joshua Huffman, Lee Shinking, and Arkia Ford. The court is going to take Arkia Ford under advisement until tomorrow at 5 p.m. The others will issue. And if they do not have a bondsman surety, then the court will find their bonds to be insufficient at this time. All right, that completes this morning's criminal docket. Court's going to stay in recess until 1:30 for the afternoon.